Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
I'm Elizabeth Morris. I'm an IP attorney and director of intellectual property and products at Pure Storage in Mountain View, California, and I am one of your hosts.
As of November 2025, the Unitary Patent System has been in place for more than 2 years. The system gave a new European option for both patent protection and patent enforcement. Applicants from around the world have used the Unitary Patent System for its advantages, some of which we discussed on a previous podcast episode. At this point, more than 22,000 requests have been made under the system, and this includes many from companies in the semiconductor industry, which rank pretty high on the list of users. But the Unitary Patent System has some potential drawbacks when it comes to enforcement. Consequently, potential filers may want to weigh the benefits and risks of a unitary patent against using the old European system. And that's our topic today. Now that we've observed it for a few years, what's the current outlook? And what have we learned since it was started in 2023? We're joined by Paul Keane and David Keane from the law firm FRKelly in Ireland to learn more. Paul, welcome back for another episode on this topic. Before we talk about the details and current status of the Unitary Patent System, could the two of you please introduce yourselves?
Sure. So my name is Paul Keane. I'm a European patent attorney based in Ireland. We are partners with a firm called FRKelly. We handle European patents and trademark filings, and we also represent clients for the UK Patents Office. My background is electronics and software and machine learning, AI, and that space. I'm working with my colleague David, who's also my brother, so I'll let David introduce himself also.
Great. Thank you, Paul. I'm a European and UK patent attorney, 20 years in the patent profession. I started my career in the UK, in London specifically. I've worked both in private practice and in-house, so I have a good perspective on the challenges facing companies in terms of my work. Software, electronics, semiconductors, my bread and butter. Both Paul and I are UPC qualified. So yeah, that's me.
It's so great to have you both. Thank you so much for coming on our podcast today. I've met you both in person. I know you're brothers. I know there's other brothers. So thank you to coming back, Paul. Thanks for joining us for the first time, David. Maybe we can do another episode in a couple of other years where we have even more Keane brothers talk to us about these things. But you two are definitely very qualified to technically, both from a legal perspective and from a technical perspective, to be on the Semi-Interesting Podcast. So we're really happy to have you here today. My recollection from when we talked to Paul over 2 years ago at this point was that there was excitement, but some trepidation about, really what was going to happen with this system. But let's just catch ourselves back up. Maybe for those who haven't really been following closely, can you explain, what exactly is the Unitary Patent System and why should a semiconductor company even care?
UPC, it's a one-stop shop. Traditionally, you would have to validate your patent in separate European countries. The UPC now has simplified that process. So there's one validation process for 18 countries, single renewal fee. So it has simplified the whole validation process. And why should semiconductor companies care? Well, they should care because their competitors are all over the UPC. Just looking at the stats current of June 2025, there has been over 22,000 requests filed. Some of the biggest names in the semiconductor industry are heavily involved, such as Samsung is number 2 on the list with 391 patents. Qualcomm is number 4. Ericsson is also there. Huawei, computer technology, digital communication, electrical machinery, to name a few, also are active filers in the Unitary Patent space.
So this sounds like a strategic tool for people in the semiconductor space, telecoms, electronics, and other things. Data shows that US companies are the biggest users outside of Europe itself, which, if I read correctly, makes up over 16% of all applicants. From a US chip company's perspective or a semiconductor technology company's perspective, what's the big advantage of using the Unitary Patent System?
I guess there's two main angles. The first one is simplicity. As David went through the old system of validating in multiple jurisdictions, paying renewal fees in multiple jurisdictions, paying translations for various language. It was an administration, headache particularly for in-house attorneys that have huge portfolios. Now with the single system, you have one renewal fee. You also have a single court to enforce it. You have the power to get an injunction in 18 countries. So the simplicity is probably the key. And again, the second point would be the power that it does give. As I said, having the ability to have a pan-European injunction across 18 European jurisdictions is a significant advantage. We can see the numbers already. There've been over 350 infringement cases. Companies are using it, semiconductor companies, your competitors are using it. So, but the main advantage is that if you have 5G chipset being sold across Europe, you can have a pan-wide European injunction, and you can bring a licensee to the table, and that's the power. So it's the simplicity and power that we never had in Europe before. Also, the difficulty with the old system is that if you were to enforce your validated patents in multiple jurisdictions, you had to take a litigation in each jurisdiction. So you could have a court case in France, in Germany, in the UK, and often you could even get conflicting decisions from the European national courts based on the same text and based on the same claims. So you get a lot of inconsistency. But they're the two main reasons where we would see companies opting to choose the UPC.
That definitely makes sense that, simplicity and power are things I think we're often looking for. And it's nice to have that option in Europe now. The semiconductor industry really lives on complex licensing deals and cross-licensing and the works. When you have one indivisible patent like this, does that mean, though, that companies lose the flexibility to do, more specific deals in more specific countries and maybe, make things a little bit more tailored to the particular situation?
That's a great question. And the answer is no. You don't lose flexibility. This is a critical point to get across, because when you think of a unitary patent, you think it's what it is a single property right. But the difference is, you can license it as a flexible contract. So while you can't sell the German part of your unitary patent, you can absolutely license it that way. For example, you can grant an exclusive license to one partner for the German automotive market, and then a non-exclusive license to another for consumer electronics in France and Italy, and another for IoT devices across the entire territory. So there's a lot of flexibility with the UPC.
So flexibility sounds great. The single renewal fee sounds great. The coverage across countries, that sounds great too. And this is a powerful tool that companies are investigating or have already started using. But like I hinted at the introduction, there's a potential catch. You mentioned a bigger hammer, but does that hammer swing both ways in any respect?
Yes, that is the major stumbling block for you have central revocation. So with every powerful tool, there's always risks, and the big risk from the UPC is central revocation. While it's great to get a pan-European injunction across 18 countries, a single revocation could also wipe out your patent. So one bad day in court could result in you losing your crown jewels. So for particular industries, particularly for pharmaceutical industries, they were more reluctant to put their crown jewels in the UPC. But we are seeing the tech companies are being more adventurous. But we can talk about a strategy on using both options going forward.
Yeah, I think I've talked to you about that before, Paul, and I think that's actually what my company's doing, is a little bit of both, and maybe we'll talk about that a little bit more. But in this high risk, high reward type environment, how should our companies be strategically approaching their European portfolios?
The key thing is to remember it's not a one size fits all approach. You need to think very strategically about your portfolio. We advise clients to think of your portfolio and try to segment it basically. And there's three main buckets that we look to. So for your crown jewels, as Paul referred to, for your critical IP, the ones predicting your core processor architecture or manufacturing process, central revocation risk there is too high. The strategy would be to stick with the classic bundle of national patents and opt them out of UPC's jurisdiction. It's certainly more expensive, but it diversifies your risk. An attacker would have to sue you in multiple countries to invalidate them. And then for bucket two, we'd look at your offensive licensing patents. These are patents you actively want to license out to use to sue competitors. For these, the Unitary patent is perfect. The benefit of pan-European enforcement outweighs the risks. It gives you a powerful tool to bring licensees to the table. And if you lose one, it doesn't take down your core technology. And for bucket 3, we look to the standard essential patents. As we know, the semiconductor industry is built on standards like 5G and Wi-Fi. The Unitary patent is made for these. It provides broad, cost-effective coverage and a single forum to resolve Europe-wide FRAND licensing disputes, making it far more efficient to manage a large SEP portfolio. So the strategy is be defensive with your core IP using the old system, and be offensive with your licensing and SEP portfolios using the new system.
To add some an analogy, you have the shield, which is your defensive using the classical system, safety, and the sword would be your Unitary patent, where how you're going to implement the offensive, bring parties to the table. So you must think of, that's what we're talking about, segmented. You must have your swords and your shield.
Does a patent applicant need to choose between the old system for safety or the new one for power? Your sword and shield analogy, for example. Is there a way that you can combine the two different options with one core invention?
Yeah, so we spoke to Elizabeth a few years ago, I think it was early 2023, where we talked about how could you segment your portfolio? How could you get the best of both worlds? I think Elizabeth really forced me to think about this way before the system came into play. But yes, you can, in that you have the option to file a divisional application. So if you take the analogy of the sword or the shield in the first, you could use your parent European application to protect your core technology and use a classical system. But you could also, before it grants, you had the option to file a divisional application, which will get the same filing or priority date. When that goes to grant, you have the option to select the Unitary patent. So you can put some of your portfolio into the classical system of a particular patent family, and some into the Unitary system. So that is, you have to be strategic about it. And you have to be strategic at drafting your applications, because you have to have that strategy in mind, because you have to be aware that there are double patenting issues. You can't have a parent application and a divisional application have claims of the exact same scope, because the European Patent Office would object to them on double patenting grounds. But there isn't a huge, you can manipulate the claims to be slightly different technically, covering slightly different scope, and yet avoid the double patenting objection. So being strategic in drafting your applications would bear in mind that I want to file a divisional, and perhaps have in your applications statements embedded detailing what those divisional claims are going to look like. If you can do that, I think you will maximize both systems.
I think that's a really good technique. It's definitely something that my company is looking at. And I know one of the things that we've looked at is like, do you maybe have broader, more offensive looking claims for instance, for licensing, right? Whether or not they're standards essential is a whole different question, but looking at one versus the other. So when you have these two systems, can you go back and forth between them as you want? For instance, can you have a Unitary patent and then get a divisional on the Unitary patent that goes back to the more traditional system, and vice versa? I know obviously the traditional system existed first, so I imagine that our listeners would assume that you could go into Unitary from traditional, but can you go back and forth? And then related to that, is there a sunsetting for the traditional system that people should be keeping in mind?
That's a great question. So the EPO still handles both systems. So it's that grant decision is made whether you use the classical system or the Unitary system. And you have to file a divisional before the European case goes to grant. You have to file it at least 1 day one day before the grant date. So you could have your parent application could either be a classic or Unitary. You could file a divisional, and you could be a classic or Unitary. And just because a divisional goes down the Unitary route, it doesn't mean you can file another divisional on that divisional and go back to classic. So that does give you options.
So you could really kind of jump between one and the other back and forth, maybe depending sort of on what happens in prosecution, or, also maybe what's happening with your competitors or your potential licensees, I suppose, right?
You can on the filing, but for example, once you select the Unitary patent, it is a Unitary patent. You can't go back.
And just to add, you can withdraw your opt-out request. So like initially, a lot of companies would be opting out, playing it safe. But now over 2 years in, companies are reassessing their strategy and maybe changing their minds. So maybe opting back in. And the transition period was initially 7 years, but there is the potential for that to be extended further. But then after that, it'll just be the unitary system all the way.
So yeah, so I'm just building on that. So that's 7 years. We have 5 years left of that. But you must remember, only 18 countries have signed up to the initial system. There was initially 25 countries to sign the agreement, but to bring it into force, only 18 countries have actually ratified the agreement. So I would expect it will be another transitional period in order to get more and more countries to be signatories of the agreement. So I would expect it's going to extend beyond that remaining 5 year period. But I don't have a crystal ball.
And just to add to that again, Ireland is one of those countries that has yet to hold a referendum to ratify the UPC. It was penciled in eventually a few months ago, but that was pulled. So it hasn't, as Ireland has to put it to the people. Basically, they haven't found a suitable timing from that, because obviously it's a complex issue. So to explain that issue to the general electorate will require some education. But from an Irish business perspective, it would be great to have that conversation started. You can see plenty of opportunities for Irish businesses, and also the potential for Ireland to have a local division of the UPC. That would be fantastic if that ever came to pass.
And at the moment, there is no common law country that is a member of the UPC. So when Ireland hopefully will ratify, we'll be the only common law country. So we would bring that influence into the judiciary and to the decisions. And so I think it is important that Ireland gets there. So at the moment, we're outside the fence, but we need to get there still. And that common law approach, it's similar to the US. There's a lot for Ireland to offer. But as David said, it is very tricky. You have to get the general population to vote on a very detailed technical topic about intellectual property. And I think that's a politician's worst nightmare.
Since you hinted at the UPC aspect, assuming you end up in a fight, either you're suing somebody for infringement or your company was sued for infringement, where is the action happening? And more importantly, what language is being spoken at the proceedings?
Well, the data is crystal clear on this. The battlefield is Germany. The German local divisions in Munich, Dusseldorf, and Mannheim are the epicenter. If you add up their caseloads, those three cities amount for over 54% of all cases, while in the entire UPC system, Munich alone handles a massive 27.6%. But here's the good news for international firms and companies. You'll probably be doing it in English. The data also shows that English is the prominent language used in 55% of all cases, compared to just 39% for German. This makes the system far more accessible and cost-effective, as you're not constantly paying for translations or trying to find lawyers fluent in multiple languages.
And just to add, the reason that Germany, it's a pan-European court, and the intention is to get the caseload and for other countries to participate. But Germany was always the epicenter of litigation in Europe. And because they had the judges, they had the tradition of litigating, it was always going to be the best location initially to go to UPC from. But that's the challenge for it to evolve to other jurisdictions. But I'm sure similar in the US, you have particular states that are preferred by for applicants. So I think that's the similar situation here in Europe. But that is the real challenge, and that's the goal, to make it a truly pan-European court system.
I'm certainly interested in this, and this idea that maybe, since so many cases are taking place in Germany and so many cases are taking place in English, it's interesting to understand that there must be some amount of court proceedings that even in Germany are being done in English. I certainly remember when I was a student going to the courts in Munich, the patent courts, and that case that was being argued argued in English. So here's another question for you guys. You said that if Ireland joins, they'll be the only common law country in the UPC. Can Great Britain join, or are they precluded from being a part of this?
Well, as you probably all know, there was Brexit, and the UK exited from the European Union. And as a consequence, this court is a European court. Unlike, say, the European Patent Convention, which isn't actually an organ of the European Union. The UK is still a member of the European Patent Convention, so you can still validate a granted European patent in the UK. But at the moment, it's a political decision that they exited, and it is a real pity because the UK profession were the leading light initially to drive the UPC and the unitary patent. But in order for them to be partake in it, they would have to rejoin the European Union, and I think they're a few years off that yet.
Seems likely. So yeah, it's an interesting issue for the UK to have to think through it, and I think for the rest of us have to think through. Then we can get this unitary patent, but we're not getting the UK system, and we still have to choose the old system for them, I guess, right? So it seems like here's another related question. I feel like and maybe I'm wrong, but I feel like about 2 years ago, we talked to you before, Paul, that there were approximately 18 countries signed up. And now you're telling me there's 18. Has there been no progress? I mean, I understand it's complex, as you guys were saying. It takes a ratification in Ireland, and you're going to have to try to explain patent law to the general population. Has that been the problem elsewhere, or has there been steady progress? And I'm just forgetting the numbers.
Yeah, so there's actually 25 countries that have signed the agreement, but they haven't ratified. Only 18 countries have ratified it. So, like, as Ireland is one of those countries that it is their intention to be part of it, but they have to get a referendum and make it change the constitution. Are they the last country to join? David, you can correct me if I'm wrong. Was Romania, which was not too long ago. That made it 18. But the interesting is that of those, I think those 18 countries, the population is probably equivalent to the United States. So it's a big market, even the way it is, and it is going to grow. But there's always been a dispute in Europe regarding languages, and at the European Patent Office, they have three primary languages: English, French, and German. But there's always arguments from the Spanish that they would want the Spanish, and there's always arguments from the Italians that they would like Italian to be one of those official languages. So I think it's going to take a little bit more time. But yeah, have you anything to add, David, in that regard?
Yeah, just to add, when the UPC opened in June 2023, 17 states had joined at that point. So yeah, Romania has been the only further state to join in that period. So I to answer your question, Elizabeth, yes, it has been a bit slow to increase the numbers of countries. And I guess it's down to, that red tape and getting documents signed. So, but hopefully, that's, as Paul said, it's still a wide coverage. So lots of benefits getting a UPC coverage for 18 states.
So if you think about the classical system, the majority of companies validated in the three main countries were France, Germany, and the United Kingdom. So you have France and Germany, huge industrial countries. It is a shame that the UK is outside that circle, but there are huge players in that. France and Germany are already there, and where litigation, people used to validate in Germany because they were going to litigate in Germany. So I think really your litigation strategy is changing. It will change. It should change. More and more companies are choosing that the route of the UPC. It's going to go away from national litigation courts in Germany to the UPC, perhaps still in Germany. But I think you're going to get obviously more consistency between the decisions.
So do you think that when Ireland joins, that there will be a shift to more litigation happening in Ireland instead of mostly in Germany? Or do you anticipate things to mostly still stay centralized in Germany, no matter when other countries join?
Yeah, I think based on, Ireland, a very important jurisdiction particularly for US corporations. A lot of the US corporations have the European headquarters based in Ireland. I think if you look at the top 10 internet companies, I think that 8 of them are probably based in Ireland. Same with pharma. The top probably 10 pharmaceutical companies, like I'd say 7 or 8 of those are located in Ireland with the European headquarters. Having that already presence of international or US corporations, plus by virtue of the fact that we're a common law country, I do think that when we become part of it and we have a local division, I think litigation will shift to Ireland for those reasons.
And one more sort of related question before I let Nathaniel ask a question. It seems to me that we've done really well. This court has done really well. It's being used. Companies are finding it effective. But in the past 2 years, we've only had Romania join, but we have 5. And as you said, probably things will get extended. But do you think that countries who are not yet involved will use the closing time frame, this 5 years? Do you think we'll see a lot more action in other countries joining in the next 5 years? I guess that's really my question.
I mean, it's difficult to predict, but I imagine we will get a few more countries joined up. As I say, I think Ireland is definitely one. I think there's momentum there to hold that referendum. So in the next 5 years, I'd be quietly confident at least that question is put to the people. But yeah, it's been a big success, and I'd say, just touching back on talking about the UK. Even though the UK is outside of the UPC, actually the validation for the UK is more straightforward than other countries, because the UK is a signatory to the London Agreement, which basically means that if a patent application is prosecuted in English at the European Patent Office, then no translations are required. So that cuts down on a lot of translation costs. So even though you may need a hybrid approach to cover the main territories in Europe, if you consider the UK to be one. It's not the cost isn't overly burdensome.
And just to add on country, I suppose, like, we're looking for the major jurisdictions, and like France and Germany, we talked about those. You probably have Italy is probably the next jurisdiction that is very industrialized and important for jurisdiction. But Spain is also, and Spain isn't participating in the UPC along with Poland and Croatia. So for us, we would like to see Spain join and Poland join. And Croatia, because there's nice beaches. We'd like those to join, but there's always been an issue with the language issue is probably holding the Spanish back, and that's probably something that has to be negotiated further. But we have, if you're a company and you want a truly valuable unitary patent, you would like Spain to be part of it, and of course you'd also like the United Kingdom to be part of it.
So this has gone from discussing patent portfolio and patent litigation options to election strategy, languages, the difference between common law and federal law in Europe, and European politics. So it's pretty clear there's a lot going on behind the headlines on the unitary patent system. Is there a final takeaway for an IP strategist in the semiconductor industry as they're examining what to do in Europe looking into next year?
Yeah. So I just think your European strategy needs to take account of the new system. Like the numbers are actually, when we're asked to do this podcast, and we've reviewed the statistics from the courts and from the European Patent Office, having 22,500 unitary patents is a significant number. Almost having 1,000 cases already being held in the first 2 years, and then you look at the companies, the big players. You can't afford not to have this system in your IP strategy for Europe, because your competitors have. And so you ask yourself, we all are aware, if you're working in the IP industry, companies like Samsung, Qualcomm, Ericsson, they have a very sophisticated in-house teams. They don't make decisions likely moving to a new system. So if your competitors are using it, it is now definitely a central pillar of European practice. And I think there used to be always the tradition of just validating in Germany, because I was going to, if there's going to be litigation, you could take an action. I think you got to evolve your strategy beyond that and make use of, as we discussed, the segmented approach, the hybrid approach, and take advantage of having some safety net, but also using its power. Do you have anything to add, David, in that regard?
Just to add, Paul, that basically it's another tool in your toolkit, and you should utilize it. It's a very, as we discussed earlier, it's a very simple, powerful, flexible tool, but you need to understand it, and you need to build it into your IP portfolio, and you need to do that at an early stage to get to maximize its value. So that my advice would be just to engage in it and see how it can power the growth of your company and help your company to achieve the goals that you want to achieve. So that would be my takeaway point.
And just before we go, almost a third of European patents now are unitary. So that's huge. And of European companies, almost 40% of their European patents are unitary. So I think you just bear in mind, if Europe is important, it definitely needs serious consideration. So anyway, that's my final sign off.
Well, David and Paul, thank you guys so much for coming on. I definitely feel like, 2 years ago, there was concern that maybe no one would use it or only patent trolls would use it or something like that, right? And it really feels like this is now a proven place that companies should really be thinking about. Anybody that sort of opted out to begin with, to kind of wait and see, maybe the time has come now to start jumping in, and hopefully we'll see more countries join as well. But yeah, thank you so much. It's great to hear this update. Thank you.
Thank you. It's been our pleasure.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.